We'll call the meeting to order. I'd like to welcome members of the public and staff and our committee members. Thanks for coming. And I'd like to introduce our committee members at this time. If y'all just raise your hand when I call your name. Kai Boyd Connors. And Mayor Patrick Hayes. Former Mayor of North Little Rock. We have another member who's not here, Eric McDaniel. He's the chairman of the planning board and he's ex officio. And that means that he has the right to vote, but according to Robert's Rules of Order, is not counted in determining the number required for quorum. And my name is Christy Eames, and I was appointed chair of this committee. I'd like to now read on statement of purpose from our agenda here. On October 26, 2021, at a regularly scheduled meeting of the Placer County Planning Board, a motion was made and carried by unanimous consent to create an ad hoc or special committee with the purpose of drafting a report to protect the agricultural and rural areas of Placer County and present its recommendations no later than a date to be determined by the chairman. Once the date has been determined, I will communicate this to the special committee. And I would like to now talk to D on the agenda, the standard rules and procedures of the special committee. The standard rules and procedures to be followed as stated in the bylaws of the planning board in section D3, except as otherwise set forth in these bylaws. The parliamentary procedures shall be as prescribed in the latest edition of Robert's Rules of Order. This is a working committee, and any such substantive recommendations or decisions will be scheduled at a public hearing before the full board. As part of committee procedure, the chair usually acts as secretary in small committees and will prepare temporary memoranda for the committee's use. These are not approved or corrected at the next meeting or permanently retained. In small committees, the chair has the right to make and debate motions. Motions to close or limit debate are not allowed. And committees use the informal procedure for boards of about a dozen or fewer members. Our board has 9, so namely this can mean members may raise a hand instead of standing and seeking to obtain the floor. Motions need not be seconded. Informal discussion is permitted while no motion is pending. If a proposal is perfectly clear to everyone, it may be voted on, even though no formal motion has been made. The chair, as a member of the board, can still, without giving up the chair, participate in debate, make motions, and vote on all questions. The committee can also appoint subcommittees of its own members which report to it. Once the committee completes its purpose, it will dissolve. And the committee conveys its views to the full board by means of a report. And the formal committee report can include a description of the way in which the committee undertook its charge, the facts uncovered or information obtained, the committee's findings or conclusions, and resolutions or recommendations. The report is given by the chair or designee and makes motion to implement the report's recommendations by direction of the committee. We therefore will use these rules to facilitate our discussions, and the public present should feel free to also raise your hand to be recognized to speak at any time. Do y'all have any questions about that? Or comments? Section E of our agenda, the Arkansas Code annotated. So the Supreme Court has codified our duties as a planning board, and I kindly direct your attention to Arkansas Code annotated 1417, 205, and 206, powers, duties, and functions, and also purpose and content of county plan. And also, I don't have this on the agenda, but ACA 1417, 204, employees and facilities. And this is all under Subchapter 2, county planning boards. And I'd like to quote from some of it because it's so important, I think, for the special committee to know the scope of our authority. So from 14-17-204, employees and facilities, the county judge may appoint such employees as he or she may deem necessary for the county planning board's work. And I believe Adam is here with us today. He's our county attorney. And Adam, I think, does that mean staff, like Mr. Clinton and
That's
Jim?
correct.
Okay. In the manner provided by law, the county may contract for services necessary to carry out the functions of the board. And the board shall be supplied with necessary office space in the county courthouse or other suitable quarters, and shall be provided with necessary equipment to carry out its activities. So in Arkansas Code annotated 14-17-205, powers, duties, and functions. The general purpose of the county planning board is to promote public interest in planning, to prepare or have prepared plans for the county, to receive and make recommendations on public and private proposals for development, to prepare and transmit to the county forum court recommended ordinances, implementing plans, and to advise and counsel the county judge, the court, and other public bodies on planning-related matters. The board may prepare and recommend an official plan for the development of the county. The board shall have the authority to confer with federal, state, municipal, and other county and regional authorities regarding matters pertaining to or affecting the planning or development of the county, or vice versa, for the purpose of ensuring proper coordination of county development with that of other political subdivisions. All public officials, departments, and agencies of the county, upon request and within a reasonable time, shall furnish the board with such available information as it may require for its work. The board, its members, officers, and employees in the performance of their functions may enter upon any land to make necessary inspections. I didn't know the board had the ability to do that.
Please exercise that.
The board shall have powers, duties, and functions in the areas of plan adoption and enforcement, subdivision and zoning, and such other duties as may be assigned by the board. So in ACA 14-17-206, purpose and content of county plan, the county plan shall be made for the general purpose of guiding and accomplishing a coordinated, efficient, and economic development of the county, or part thereof, in accordance with one or more of the following criteria. The plan shall seek to best promote the health, safety, convenience, prosperity, and welfare of the people of the county. And some of these items listed are the conservation of natural resources, the protection of areas of environmental concern, the development of land subject to flooding. It speaks about orderly development. Areas of critical environmental concern include, among other things, aquifers and aquifer recharge areas, soils poorly suited to development, floodplains, wetlands, prime agricultural and forest lands, the natural habitat of rare or endangered species, areas with unique ecosystems, or areas recommended for protection in the Arkansas Natural Areas Plan, which I don't know what that is. Plans for these areas shall give consideration to protective mechanisms which seek to regulate activities or development in the areas. So I encourage new members to go on to the Arkansas Code annotated, maybe look through some of that section. Very interesting. Now I would like to ask our planning director, Mr. McClendon, and ask that he give this body and the public a brief overview of the current issues regarding the need for a countywide land use plan, including protecting the agricultural, rural, and natural areas of the county from uncontrolled growth, due to leapfrog developments that they are currently experiencing.
Well, in general, Pulaski County is the most urbanized county in the state of Arkansas, and as a result, there's a greater demand or pressure for development in unincorporated parts of the county. Part of unincorporated Pulaski County is regulated by cities through their extraterritorial planning jurisdiction, which includes zoning in a couple of cases and subdivision regulations in others. The balance of all Pulaski County, the floodlands are regulated by the county, whether it's in the ETJs of the city, extraterritorial planning jurisdictions of the cities or not. The history of planning, especially more land use planning, started, a number of years ago with the adoption of the first land use plan in Pulaski County, unincorporated Pulaski County, in the Lake Maumelle watershed. That was an area studied primarily to create regulations to protect the water supply of Central Arkansas. And when I say Central Arkansas, I think that's actually growing, because Central Arkansas Water certainly has ambition to extend their water service far out from Little Rock. As a result of that, the Pulaski County went through the land use planning process to develop regulations and ultimately adopted those regulations for Lake Maumelle watershed. Secondly, more recently, there's a study underway called the Compatible Use Study, and that has to do with regulation around Little Rock Air Force Base and unincorporated and incorporated parts of the county. As a result of that, there's likely to be a further land use regulations in the northeastern part of the county to try to protect the mission of the Little Rock Air Force Base. So, having said all that, that would lead us to the point of where we are now, which is more intense development in certain locations of unincorporated Pulaski County, and how that would affect or how it might impact other areas of the county, adjacent and otherwise. So, which led the planning staff to say it's probably time to look at developing a land use plan for all unincorporated Pulaski County that the county regulates. And as a result of that, the staff created, the planning board discussed, and the staff created a resolution to the effect to say that, it's probably a good time to start looking at land use plan. The land use plan, there's a couple of things involved. First off, you have to do a land use study before you can do the plan. And ultimately, probably certainly we'll have to have consultants to do all that. And once you have a study and then a plan, then you can create regulations, if you so desire, to regulate based on that land use plan. And those things would have to be ultimately adopted by the Pulaski County Quorum Court. They'd have to be supported and funded by the Quorum Court, actually. So in that regard, I guess, what this process is to establish the need and the direction for where we probably want to go, and get it to the Quorum Court and have it ultimately supported and adopted by the Quorum Court of Pulaski County. Once that happens, then we can start the process of the study and the regulations, the study and the land use plan, and ultimately the regulations. So that's kind of how we got to where we are today. So I'd say that pretty much sums it up.
Thank you so much.
Welcome.
Does anyone have any questions about?
Yeah, one question.
Okay.
And what's the, because I know what the law used to be on annexation. Is it still the city adopts a resolution that includes what area they want to annex, and then there's an election in the city and the area to be annexed, and that's the total, or have they changed that?
Well, there's several ways that you can annex. Voluntarily, you can petition to annex into the city, and then you have to have majority of the owners own a majority of the property. And then you can get it annexed that way. Secondly, you can annex by virtue of unincorporated islands, or enclaves is what they've ultimately defined it in the state legislature now. But so that's where the city initiates it on its own, and because those are prohibited or discouraged, I guess, discouraged in the state law. And thirdly is what you mentioned, and that's the referendum method of annexation. So that's, I guess it's a majority of the vote of those in the incorporated and proposed incorporated area, if I remember right, if that's correct.
That's the way it used to be.
And which gives the city a great advantage typically, because usually if the city makes its case, it would support the annexation, and the ones that I've been involved in anyway.
I remember North Little Rock, before I went to City Hall, tried to annex Maumelle and was unsuccessful in the vote. I think that's the way it used to be.
Yeah. Tried to annex the city of Maumelle?
Not the city.
But
it wasn't
the extraterritorial jurisdiction of Maumelle?
Well, Maumelle was not incorporated at the time.
Oh, I see.
The city tried to do it. It was an unincorporated community.
Right.
Later, it incorporated.
Right. Yeah. So the possibility is there. And years ago, many years ago actually, when I worked at the city of Little Rock, we did a lot of annexations. In fact, we doubled the geographic size of the city of Little Rock in that process. And so it's a contentious in some instances, and certain parts of the county, if I recall, I know so, in fact, they were very concerned and afraid that Little Rock was going to extend their jurisdiction out to do it. And they have extended their extraterritorial planning jurisdiction and the zoning. They're able to zone like North Little Rock is able to zone, and
Maumelle can, but doesn't.
Maumelle can, but chooses not to. So the two cities that zone extraterritorially in Central Arkansas are Little Rock and North Little Rock.
What is that? I know it was 5 miles at one time. I think it changed.
It's less.
Yeah.
It's dependent upon the class of the city. They've reduced it. So it's 3 miles, I think, for Little Rock. And then, so they could do zoning and subdivision. And North Little Rock is at 2 in there. And then Maumelle would be 1 if they chose to do the zoning. So it has to be on a navigable stream. So whatever the cities of the first class are on that, I think. So.
Are there any other questions?
Point of information.
Yes.
It's my understanding, and I'd like to ask Mr. McClendon if this is correct, that the concerns from citizens and the issues that have brought us to this fine meeting today are in territory beyond any of these boundaries of extraterritorial jurisdiction. The leapfrog element comes in, which goes way beyond not only the city boundary, but the extraterritorial boundary. And this is literally a blank slate on which we need to write some protection for the property owners there now. Is that a fair statement?
I guess it depends on your point of view, but I understand what you're saying. Typically, the more intense development occurs either in the cities or adjacent to the city limits. And I think the issue for all of this is the primary issue, I think, is sewer. Package plants in particular. And because you can't have intense development, and when I say intense, I mean small lot development in unincorporated areas without either a sewer improvement district and extension from a cities to extend sewer outside its corporate boundaries, or a package plant. And the package plants have become a lightning rod for that kind of development, I guess. And as a result, the city of Little Rock changed their zoning regulations to require package plans to be approved through the conditional use process, if I remember correctly. And so the county does not have zoning or conditional use permit, so there's no way to regulate that aspect of it. So that's I guess that's probably a driving factor, or one factor anyway, of the land use plan. That's how we got to where we are.
And I think that CAW bans treatment plants in their watershed.
Yeah, the Lake Moma watershed, they're prohibited. Well,
State prohibits.
yeah, the state prohibited them, and well, you can have septic,
No,
but they have to be
no
they're
surface discharge.
Yeah, no surface discharge of sewer, like drip lines or anything like that in the Lake Moma watershed, and so they're very heavily regulated relative to the rest of the county and the state, really, with regard to that. The regulations that the county adopted, incorporated that, and the state legislation also was created to protect water supplies, municipal water supplies, but that's what I think they termed it, municipal water supplies.
So that would include such places such as corporations such as the Monmouth Water Corporation, with discharging potential effluent into tributaries near their wells.
Well, that would be the health department that would be involved in that. So if there was an issue, a conflict there, that would be something the health department, ADQ, should take up.
Are there any other questions? Thank you again for coming to that. So now I'd like to discuss the main topic today is the proposed resolution that the planning board staff has asked the committee to review and give us an opportunity to comment. Does everyone have a copy of the edited version? It's highlighted. I'd like to.
It's in the chair right up here.
Okay, it's
If
fine.
you want a
It's all
copy.
right. It's copy right here. And since the edited version has the original in it, I'd like to go ahead and just read through the whole thing. I'm sorry it's going to be painful, but I'm going to do that. A resolution by the Placer County Planning Board recommending the full report of Placer County adopt a countywide land use plan to include the protection of agricultural, rural, and natural areas. Whereas Arkansas Code annotated, I won't read those, allows counties to adopt plans for general purpose of guiding and accomplishing the coordinated, efficient, and economic development of the county or part thereof. And whereas Arkansas Code annotated allows the Pulaski County Planning Board to prepare and recommend an official plan for the development of the county. And whereas, this is the part I added here. Whereas the unincorporated portions of Pulaski County, Arkansas, have been undergoing rapid growth, and whereas, as a result of said growth, there has been a collision of interests among agricultural, residential, commercial, industrial, environmental, and recreational uses of land, and whereas the Pulaski County Planning Board has heard in the course of several public hearings the concerns of property owners and the community, and therefore have undertaken consideration of the need of a countywide land use plan to protect the agricultural and rural areas through the formation of a special committee. At their October 26, 2021 meeting, by unanimous consent, we purpose to submit final recommendations to the full board on how best to protect these areas, no later than a date to be determined by the planning board chairman. Whereas, the Pulaski County Planning Board has undertaken consideration of the needs of the countywide land use plan to protect the character, integrity, and viability of the agricultural, rural, and natural areas of Pulaski County from uncontrolled growth. That was something I added. Protect land value and investment of the properties in Pulaski County, another one I added. Ensure and accommodate orderly growth and responsible development that respects existing communities and including their infrastructure or lack thereof, another add. I'll read my comments after I read the whole thing. Protection of areas of environmental concern, including, among other things, aquifers, aquifer recharge areas, soils poorly suited to development, floodplains, wetlands, prime agricultural and forest lands, and natural habitat of rare or endangered species, areas with unique ecosystems, or areas recommended for protection in the Arkansas Natural Areas Plan. So I did take that from, directly from the code, from the state of Arkansas. Lessen congestion in the roads and streets, promote security from fire, panic, and other dangers, promote health, safety, and the general welfare. And I added this. I struck out provide adequate light and air, and I added reduce light, air, and water pollution, especially in the areas of watersheds, wetlands, tributaries, and other natural areas. Avoid undue, I think that's supposed to be concentration of population. And then I struck out the last bullet point to facilitate the adequate provision of water, sewer, schools, parks, and other public requirements. Because I felt it was covered implicitly in the above bullet point, ensuring accommodate orderly growth.
Which one was it? I'm sorry, it was referring to.
The facilitate the adequate provision of water, sewer, I struck that out.
You're gonna do that, somehow you said it referred to it.
Oh.
Which one?
Yes, the ensure and accommodate orderly growth and responsible development bullet point. It's on the other page.
Oh, okay.
Sorry. So whereas
We
the
said
Rocky
it's
County
okay to
Planning
strike
Board
that.
has held
But we
duly
said
publicized
it's
public
okay to
hearing
strike
on blank and blank to receive public comment on the proposed countywide land use plan. And I added to include protection of agricultural, rural, and natural areas. That therefore be it resolved by the Clackamas County Planning Board that, I moved the first section to the end. Section 1, the quorum court directs the county judge to appoint a task force no later than March 16, 2022, special committee meeting, and that this task force make a report with recommendations regarding countywide land use plan to include protecting agricultural, rural, and natural areas of Clackamas County to the special committee no later than July 13, 2022, and that this task force be known as the Protecting Agricultural, Rural, and Natural Areas, or PARNA Task Force. Section 2, that no later than March 11, 2022, the current land use map of the county be presented to the special committee for information purposes, and then forwarded to the PARNA Task Force for use in their work. Section 3, that the PARNA Task Force be co-chaired by one member each from the Clackamas County Planning Board and the Clackamas County Quorum Court, which I spoke with Adam before this, and we can't do that. We can't have a quorum court member. And be made up of Clackamas County stakeholders representative of the areas and interests likely to be impacted by subsequent action regarding future growth management, including property owners and local community groups, agricultural and environmental communities, mayors, business, real estate, and development. Section 4, that the quorum court charges the PARNA Task Force with the responsibility of drafting a countywide land use plan to include the protection of agricultural, rural, and natural areas in Clackamas County, report and recommendations. Section 5, that the report and recommendations for PARNA and Clackamas County include identifying issues associated with the growth the county is experiencing in rural unincorporated areas, and determine how best to protect the agricultural, rural, and natural areas, while at the same time ensuring and accommodating orderly growth and responsible development consistent with current uses and infrastructure, recognizing the consequences of uncontrolled growth on the character, integrity, and viability of these areas. Section 6, that the task force provide the special committee a thorough PARNA report and a draft ordinance regarding PARNA no later than September 7th for public comment and edits before final consideration by the full planning board at a regularly scheduled meeting. And finally, section 7, which is used in the front, the initiation of a countywide land use plan process to include the protection of agricultural, rural, and natural areas is hereby recommended by the Pulaski County Planning Board and forwarded to the Pulaski County Forum Court for their consideration. Thank you for enduring that, and I just wanted to go back and make some comments that I didn't make during it. I wanted to note that on the first page, the bottom, the bullet point, ensure and accommodate orderly growth, I did find the word orderly development is mentioned in Arkansas Code annotated 14-17-206, number 7. And on the second page, the first bullet point, I did take that directly from Arkansas Code. That's the protection of areas of environmental concern. And the bullet point starting with provide adequate light and air that I struck, I wasn't sure what that meant, Mr. Clinton, and I thought maybe you could explain that. I tried to explain it in the way I thought, and in the way some community members have expressed, which is right here. So I wanted you to explain that. Could you explain that now?
Provide adequate light and air? Is that what you're asking me?
Yes.
My way of thinking it would be to create and promote development that provides a reasonable space for people, and for safety purposes too, like to be well lighted or something like that. I don't think they were talking about light pollution, but
I can offer some commentary.
There you go.
In early land use law, there were cases where buildings would be built next to buildings and windows would be blocked. And it resulted in litigation over whether somebody had a right to the light, whether by virtue of the existing construction they had obtained a right to continue to have light coming into their spaces. And so that's ordinary language that you see a lot in adequate light.
Was reduced, under Christmas when it reduced light, air, and water pollution, especially in areas of watershed. With that umbrella, perhaps include trying to reduce, greenhouse gas emissions, in terms of automobile pollution, combustion engines, fossil fuel combustion engines.
Lighting has a big impact on whether people need to drive cars.
I know that, Madam Chair,
Oh, yes, yes.
I know that one of the things from our perspective in North Little Rock, we were pretty well surrounded by the jurisdictions, and 24 years I was there, we didn't forcibly annex or make an effort to forcibly annex anybody. We voluntarily annexed folks like Dan explained. But I think that the time is right, and I think one of the big focuses that we ought to have is directed toward doing something that will help the whole county make some progress on the reduction of greenhouse gas emissions. And I don't know if that's what to do that, but I think that should be included in our, at least our thought process. Number two, let me see if I can recall, man. I know Christie is certainly interested in the rural areas, and I am too, in the protection of those. I think that's critically important. But also, I kind of come a little bit too from the urban and suburban perspective in terms of, what I think we ought to try to do is to keep all of our interests reflective of what we want this county to look like in the next 5, 10, 20, 30 years. I do have something here that may not be, because of changing weather patterns, it may may be fairly radical, on all of us, a lot different than we hoped, but I think that both greenhouse gas emissions or climate change ought to be a consideration, and I think, now I know that in reading Christie's language, it appears to me that the committee was formed for the protection of agricultural and natural areas. Is that correct, or was it to have a county-wide plan? I don't recall.
Well, I think the language may have been used about agriculture, but I don't think that should be specific to what we're doing. It ought to be a plan that would ultimately develop sustainability issues that you mentioned, and the land use in the county, whether it's rural, urban, suburban, and how they intersect. That's the whole point of doing the study, to see what you have, and then the land use plan that a consultant would do to see where you would go, or where you'd want to go, and how everything interacts, and where you'd want to go in 5 or 10, 15, or 20 years in the future.
Because a lot of the language in the resolution, I think there are a few things that just don't, like protect land value and investment of
Right.
properties within Washington County.
Right.
Would it be protect land value and investment in the properties of Washington County?
Well, we have
It's just some drafting, so
No.
may or may not, if it didn't, I'm just curious as to what your temp was.
well, as far as these proposals go, the staff has significant concerns with many of them.
But our committee was formed for the protection of, to study the protection of agricultural and rural areas. That is a matter of record. And that was what was passed, and that is what our charge is. And that is our focus as a committee. And then Mr. McClendon sent the resolution asking for a countywide planning plan. And I feel that, of course, that should be part of this committee's study, but that we have been asked through the people have, attended our meetings. There were many concerns about the economic developments in the county, and so this committee, I want to make sure that the focus of this committee stays what we were charged with officially from the board, which was to protect the agricultural areas. That is what we're supposed to be doing. Unless we go back to the board and revise that, in my opinion. But Adam, I guess we can move in, of course, the countywide piece.
Well, I'll offer this. I don't think that what y'all are saying is inconsistent. I think that development of a land use plan for the county, part and parcel of that is identifying which areas are best suited for agricultural purposes, best suited for forestry purposes, have ecological attributes and habitats that are not only desiring of, but are best suited for protection. So I think in order to identify those areas that are best suited for development, you also have to identify those areas that are less suited for development. And so those it's hand in glove. They go together. And if I can offer a little bit of commentary, this is not a legal analysis, but I think it's with respect to the resolution itself, I feel like this is a little bit cart before the horse. I think in terms of where this subcommittee is today, you can certainly ask the planning board to adopt a resolution asking the quorum court for resources. I think you can certainly ask the planning board to adopt a resolution that alerts the quorum court to the fact that they have made a decision to start the process for land use consideration, and part of that is asking for resources so that y'all can be supported. And so I think the path that this is going down now, it looks more like a resolution that would be adopted once a land use plan is ready for presentation. that's at the, you're at the end already, and we're just at the beginning. So I think taking that step back may be.
That was gonna be my question, Christie. When some of the language has made a finding regarding, when you say the undergoing rapid growth, like how is that, how are you basing that? What data are you using to make that determination? I think, you know, before you categorize what the complaint from the community is, you have to do an assessment of what it is and how you do that. You use data, and you need somebody to come in to say, well, this is what the growth looks like compared to years prior. And so I think you have to balance, similar to what Adam is saying, the agricultural concerns with, you know, the development concerns. I don't think one goes without the other, because we've got to grow as a community, right? People are gonna still move here, people are gonna need places to live, so where are we suggesting those individuals build and live? So I think, I agree that we need to do maybe some type of research to make the resolution or the, you know, the determination that that is what, these are the things that need to happen, before we can say something is uncontrolled growth, or, you know, something is irresponsible or not responsible, or responsible growth or development. Because how do we categorize that without the data?
Point of information,
Yes,
next door, we have another plan, which has just published their new latest study. They give you all of that. Those people get up and go to work every day to produce exactly that. It's not posted on their website. You can get on their release list. You can ask them, or there may be an official who has to make the request. I'm hazy about that. The drilling down into the data. But that is readily prepared already and available for public viewing, and should be incorporated into this. I'd like to add a couple of form comments that go back to Mayor Hayes' remarks on greenhouse gas and growth. In one sense, the ship has sailed about the expected growth of the county. By which I mean, years ago, I received a briefing from the director of the sewer utility. If you go and ask today's briefing on the sewer treatment plant at Pinnacle Mountain, you will find that they are currently running sewage from certain sources through Module 1 of sewage to be treated. This is one of 4 expected at full build-out. You need to start asking yourself what people's expectation is at full build-out. Because it turns out the sewer people expect the existing city of Little Rock, from the airport and the port all the way to west of 430, to be flopped over and reach the Pulaski Perry County line and duplicate the size and the population we have today. They just expect it flat to double in decades to come. So they are expecting this to come in that orderly fashion, so that they need to crank up modules 2, 3, and 4 to run as much sewer in that gravity well to handle a duplicate to the city of Little Rock today. So all of these folks who are out there in the country on the road to Perry County have this freight train of development bearing down upon them. Particularly, as I have heard in more than one meeting, I would like my wonderful lifestyle to be given to my children to enjoy after my death. And you know what? That's on a direct collision course with the expected development out Highway 10, out Canis Road, and so forth and so forth and so on. Now that's beyond the particular area where Christie lives that has a particular series of clashes and friction points today. But it's coming. And you should widen your research and your data collection. And you damn sure need to get a briefing from the sewer utility, because they've already built for it. And As you've always pointed out, that's the limitation. So once they've got you sewer, there is no holding them back. Be prepared. The other point I'd like to make is about mass transit and, the ability for the current system to move out into these areas. Right now, it's a disgrace that the bus service stops where it does out Highway 10. And one of the ways that we can deal with a surfeit of cars near Hayes is you get mass transit running up and down. And right now, they are moving to Array, not more big buses with 50 passenger seats, but on-demand vans with 12 passenger seats. And they're focusing on like the commute runs. All those things that could relieve the traffic pressures on these rural roads as more people move out those rural roads. So that's a conversation in a briefing that should be included in your task.
Do you, Chair, do you mind, if you speak, the audience, I'd love to know, y'all know who we are, would you mind identifying yourself?
I'm Kathy Wells. I'm president of the Coalition of Little Rock Neighborhoods.
Yeah.
And since we formed in 1990, one of our desires is that we have a growth to plan, a plan to growth. Sorry, let me try that again. We plan the growth of the city of Little Rock, and we have not succeeded worth a damn till yet. So we're just thrilled that somebody wants to plan growth somewhere and raise all these issues up and lay them out on the table, so you don't get run over by the development bus and you didn't even know it was coming at you.
Look, if I could, Christie, because I got a little confused in the language about, we're gonna ask for another committee to be formed.
Yes, I talked with Adam before the meeting today, and he indicated that we would be that committee, that we would be part of it.
So we're gonna need, so some of your language in here is not, we're gonna be a part of another committee. I mean, a part of a bigger
We
committee.
could form our own subcommittee. And
I can clarify,
Yes.
there's no need, y'all are a subcommittee.
Yeah.
So what is described in here with respect to your vision for Parna is this committee. And so I think you could I think it would be most appropriate to take out the call for a new committee, because you don't need to ask, if a new committee is gonna be created, the planning board can just end this committee. There would, you don't need to duplicate efforts.
Well, do we need any, we'll say, endorsement by the?
And you don't need endorsement in order to undertake the work. However, if, kind of going back to my original comment about where you stand today, I think it's appropriate for this committee to ask the board to alert the quorum court to the existence of this committee, the work that it is preparing to undertake, and the determination of the planning board that, we think it's appropriate to go ahead and start the work to develop a land use plan. But in order to develop a land use plan, what's really needed from the quorum court are resources. Resources.
Yeah.
And so a request to the quorum court to appropriate adequate funds, whether it's all this year or this year and over the next year and a half, whatever that tenure is, these things they take some time. But I think it would be appropriate certainly it's appropriate for the board to ask the quorum court for resources. It's certainly appropriate for the board to alert the quorum court to the work that's being undertaken. But I don't think you need to ask the quorum court to create a committee when this committee already exists to serve the purpose of the anticipated committee.
so, with that, then, there's a bunch of stuff I need to strike out and re-edit. And I know we're coming up to 1 o'clock. Oh, Mr. Flynn, do you have something?
Yes, I'd say that if you look at the proposed resolution that we started with, I think what's happened or what's happening is an effort to go beyond the beginning towards the end. So that's why the resolution is more in generic terms, because the point is that you go to the quorum court with the fact that we have a committee and the planning board has looked at this issue and we think there's sufficient reason to request those resources to do the kind of work we need to do. And at that point, they give us the resources to go out and discover all the things that might be in here instead of trying to say what's in there before we even get started. You see what I'm saying?
Yes, and when you say us, you mean this board.
Correct. So in the resolution, for example, as simple as it is, it's similar to what we did with the Lake Momel watershed. They know, once they know that there's a need or there's a reason for it, and you can explain it to them, meaning the staff or whoever comes to the court, then they can make a determination whether it's worthy to proceed and then come up with the monies for it. And one thing that would be added in here, I guess, from what we started with, is that there's a subcommittee of the planning board that has looked at various issues and listened to the public, and then we bring this resolution to the full board, and then the public can comment, or we have a public hearing and people can say what they need to say, and then we take that on. So we've shown the quorum court that we've done our due diligence, that the staff recognized it, the board recognized it, we established a committee, we've had public hearings, and now we're coming to you because we think we have an issue and this is the issue. And then when you hire the consultant to do because these time frames are completely unrealistic. This is gonna go on, if we do it like we normally would, it's gonna go on a couple of years probably.
Well, Northwest Arkansas was able to do it.
Well, I would not say that that's the role model that we want to use. They have a very simplistic plan that creates nothing but controversy on anything because they wanted to take the simplest, easiest way to get there. And I'm saying there's an element of that is desirable, I guess. But if you want to really do the study and the plan for the whole county, then there needs to be more to it than just all residential and farm uses are by right and everything else is a conditional use permit. That's just nothing but it's a recipe for lawsuits and dissension, and I don't think it adds to the orderly growth. I think it just creates more issues. But that's not for me to say. That's for the study of the consultants that we hire. They certainly can look at Northwest Arkansas because that's the only county that has full countywide zoning as far as I know. There's some, Crittenden County has some kind of thing. I don't know. They never used it, but.
Could we use your resolution, modify it I would like to have to include the protection of agriculture, rural and natural areas. Do you see any problem with that?
I don't see any problem with including that's included in the scope of what's being reviewed.
Yeah,
So we can include that in the title, and then would we scratch out a bunch of stuff, but whereas the Pulaski County Planning Board has heard in the course of several public hearing sections, could we leave that in the resolution?
Well, it would be, because we're gonna, when we create the resolution and the board says this is something we want to do, then we'll have as a public hearing for them to discuss, and then we'll have the dates in there. And I don't think that it needs to be in the title. I mean, if you want to, in one of those bullet points, put that, you want to discuss, or the idea of rural, urban development and agriculture, or whatever, however you want to say it, I think that's fine. I think we don't want to prejudice our, how should I say it? I think there could be some legal issues associated with it too, possibly, but we want to say that we want to do a land use study for the whole of unincorporated Pulaski County, which includes rural, urban, suburban, agriculture, commercial, industrial, all of it, so it's okay to recognize it, but I don't think we want to focus on it.
Well,
Okay.
the board was told,
Well, the board can reconsider it.
Our committee was formed to protect
Okay.
the agricultural area.
Well,
So, but I still don't, I'm sorry.
Well, no, go ahead, I'm just, when
But
appropriate.
I don't see why we can't include the full county in this resolution and, keep that title. In my opinion, it's okay. And I'd like to leave in, for example, scratch the whereas incorporated the uncontrolled growth part that Carl didn't like. scratch that, scratch the result of said road, so there's an collision of interest, scratch that. Leave in the whereas part about the board, if that would be possible. And then, we can scratch those first 3 bullet points, maybe, just a suggestion for the public to think of as well. And, because I know we're at 1 o'clock, and I really would like to get this approved by, for us to make decisions.
I think we're gonna have to meet Christie and figure out, language, because the purpose of the resolution is to, charge us with getting to the goal we want, right? We want to protect agricultural wetlands, that's what we want to do. But in order to do that, we have to obtain resources and understand land and what the best purpose or use of that land should be.
Sure.
And so we can't isolate, competing interests with that. So I think we need to create language that's just all inclusive, but yet it still gets to the goal and objective that we want. I think we can do that with different language and have it rooted in facts. If we say there's a rapid growth, we can cite numbers and say, according to, put a footnote or something, metro plan, we have seen, development, propel in the last 10 years, causing whatever, an encroachment on certain wetlands, and whatever the language we want to use. And so we need to balance that with, growth of suburban and metro areas. Whatever the language is, I think we can create it, and it still reaches the goal, and it doesn't isolate competing interests. I think there's a way to do
Let me,
that.
if I could.
Yes.
Sure, I agree, Christie, I would admit, overall, the whole goal, as I see it, is to give a document, I don't mean, watered down or anything like that the full court will approve. Because if we worked our, back ends off and gave them a serving of something that they just laughed at, then, I don't say laughed at, they, because members of the forum court represent urban, suburban, and rural, and, protected areas. So they've got a broader interest, and what we want to serve them is something that they'll vote for. Because if we don't, then, our time is going to be wasted. I'm thinking, that what we want to do is from a diplomatic standpoint, make sure the forum court knows what we're doing. It does not have any immediate concerns that they want to give to us. Now, I'm certainly not arguing with the issue of whether we ought to protect, rural and special properties. Let's see, agricultural, rural, and growth. But I think, we don't want to do something that is not ultimately, at least has a chance of getting through the court.
Okay, sure. I did. I think I understand that, we
So-
should go back to the simplified.
Well, I'm sorry.
Oh, no, I'm sorry, were you finished?
Well, I was just gonna say, I'd like a little guidance, maybe our county attorney can do that. As I think, is that we, rather than serve them up a meal, we need to, tell them we wanna go to a restaurant. In terms of an analogy. And then they say, but we want you to consider this, that, or the other, at least give them a chance to give us a charge.
Well, but if you're right, then, if we go back to this, and if we don't put in the title, and we put in this bullet point from the Arkansas Code annotated, protection of areas of environmental concern, I think that would be appropriate, because that's actually in state code.
That's fine.
And, I would like to leave provide adequate light and air.
What does the public think about that?
I think that's important to keep that language. My name's Miranda Moore. I live in Roland. We have 67 acres. We have some wetlands on our property from a portion of Mill Bayou runs through it. I'm here because there's already rapid growth trying to happen right now with developments and wastewater treatment plants that will be discharging into Mill Bayou. My property is the top of the receiving end, and there's issues with it, with flooding, and my pasture's flooding, and just concerns with extra water flow going through there. It floods every time it rains. It's a very special timber wetland that for the future of our kids and I'd like to see that rural integrity stay. And I like the idea of keeping the open spaces, the light, the air. I personally would like to see, land uses where these unincorporated areas stayed at a low density, to keep that medium, high density residential areas from happening, where properties aren't, 5,000 square feet. They're 15,000 square feet or more, where people have space and elbow room, and that integrity of living out in the country isn't ruined. So that's why I'm here.
Would it be proper, I'm sure, to ask those that are here to, if they're so inclined, if they want to remain anonymous, it'd be fine with me too, to kind of give us an idea of who, I know
Yes,
Kathy.
introduce yourselves if you'd like, unless you don't want to introduce yourselves.
John
Anyone?
Clements, I'm in Natural Steps. Been out there for 33 years. And moved out there to get out in the country, and it's definitely changing. They just put a 70 by 200 building across the street from me. Big metal eyesore for me. The rest of the community might like it. But, personally, I mean, they got 4 bathrooms set up in that one deal on 3 acres. Got a car shop in it now. Got air tools running all the time. I mean, noise is just crazy. Right in a big curve, all the traffic danger, trying to get boats and RVs in and out of it. Then you go and dump 76 homes, what is it? Paradise Valley, times 2. As far as cars, traffic, more. It's got to come up 300 to get to Laurel.
300 is not ready for that
No, not at all.
You could give me a little West Little Rock for all the money in China.
But I mean, it's just, I don't know where it's gonna stop. It's all about money, that's all it is. Strictly money. The guy was able to buy that piece of property across the street for pocket change, and he'll have it paid for within a couple of years, and it's, you don't care what's around him, and he's got houses right behind him.
And the way that the cities protect folks is zoning, so that, I can't put my shop next to your house. And, that is a whole separate consideration, that you might want to privately begin to educate yourself on outside the scope of this committee. When you talk about a plan for the unincorporated counties, you don't start out thinking that we're gonna get to the kind of zoning we know that Little Rock and North Little Rock has. But when you're talking about protecting someone from an undesirable enterprise of a very different type of activity next door and across the street, as far as I know, the only way we do that in this community is zoning. Now, a lot of people get very concerned about the evils of that, but, it seems to me they invented it for a good purpose, and it mostly provides good protection for folks. And when you want to rezone in the city, all this stuff that's dirt today, it starts out being R2. And then you gotta go before an authority that says, oh, I wanna put in a subdivision, so it's gonna be multifamily. I'm gonna put in a commercial C3 where that shop of yours could go in. And there's rules about that. And they can't be next to each other. And so forth and so forth and so on. Now, we've gone way beyond what we started out thinking about. And you certainly should be getting guidance from folks like the county attorney, who is far more versed in this than I am. But I want to get it into your head, that may be what you grapple with by the end of the road. So you better beginning to learn and create a file of information and create a list of knowledgeable folks that you thought you could trust, who can tell you about the pros and the cons of this.
Thank you, Kathy, and thank you, John, and we have Miranda, she's introduced herself,
And I'm Cheryl Stephen Rowe, I live out in Roland. The Bible backs up behind us and floods, our property on a regular basis, just when rain. But we moved from West Little Rock to get out there to enjoy the country. We've been out there 10 years, and we're concerned with what has been, what potentially could go on out there and affect our property.
thank you, Cheryl, and Dan.
I'm Dan Scheinman with Audubon, and I would like to see the words water, light, and air pollution remain in the resolution because those are important metrics of the effects of development on rural, agricultural, and natural areas.
Okay, so what I'm wondering is to try to end the meeting. I know that it's past 1, and would it be advisable to go back to the original and in that add the bullet point protection of areas as we discussed with the ACA 1417-206, and then keep in reduce light, air, and water pollution. We could leave that in and scratch provide adequate light and air.
I think we should keep provide adequate light and air, and
Okay.
just add.
Okay.
Yeah, I think we can keep both.
All right.
Because providing airspace and light rights, light and air rights, if that's what it's
Okay.
called,
Mhm.
I think would, I remember vaguely from law school. Where, yeah, property law, you have airspace rights, to a certain degree.
Maybe say respect light and air rights.
One of the things, if we could, Madam Chair.
Yes.
I have got to have, I can't vote without having.
Oh, yes, I was wondering, would you authorize me to redraft this? What I'm talking about now is these changes, if I could do another draft. And, I know that we went to, I would like, if we could, have it before a full board this month. Would you like to have another meeting, or do you want?
Because it's subject.
Well, we could
Doesn't
zoom it.
allow, we've got
We were
to-
gonna talk
You
about
wanna-
that.
could we
maybe.
zoom?
I think we need to Zoom
Okay.
meetings going forward, just like we do with the planning board.
Okay.
One thing I would like to add is all these various concerns, sustainability and air and light and all these other things, the point of hiring a consultant will be to incorporate those things as they discover them and see them and hear them, and they'll have public hearings, so people that have specific concerns can come to those meetings and say, well, have you taken into consideration this or that, and those can all be incorporated in the land use plan.
Okay.
And
It'd just
then,
be a warm fuzzy if we could have that protection of areas
well,
environmental.
yeah, I'm just saying, we probably ought to just start cutting off, trying to put everything we can think of in there.
Sure,
Just get a basic resolution and put a couple things in there that you've talked about. And then the key is to get it to the planning board and then from the
Yes.
board on to the quorum court, because that's where the process starts.
Okay, so should I go ahead and redraft it? And Mr. McClendon, you can set us up with a Zoom maybe next Wednesday? Would that work for y'all?
When-
Maybe
when-
tomorrow.
Where you doing the noon hour?
Is the 8 hour okay?
I wouldn't be able to attend, but, you know.
Oh, no, definitely not be there.
I've got another.
What's,
Wednesday will be okay for me, but that's,
What days are y'all available next week?
is Martin Luther King, it's on Monday.
Correct.
That's a holiday?
Yes.
That's what it is, that's what I thought. So Tuesday, I'm not available around noon hour. I got a hearing between 1 and 3.
Or could we even email each other? I can just email it, and then
Well,
y'all
I mean,
can
we would have to
respond.
have something to
Or
look at.
email Van, because Van can distribute, you avoid the open meeting stuff. Y'all start emailing each other
Okay.
on content that you're gonna consider, it can get a little hairy. So if you want something distributed, send it to Van and he can distribute that to
So
everybody.
you can distribute it just to the subcommittee.
Sure, if that's what you want.
And then, if we have comments on that, we email
Send it to Van.
Van back. But can they do reply all?
I would suggest that you not. I would send it to Van and Van can compile them and then you'll have a menu of options next time you show up unless
So-
you really can't you can't discuss and formulate between the meetings. You really need to do it in the meeting.
So a Zoom is really best. Okay. Well, what days are y'all available?
Any day but Tuesday, or the 16th.
I've got,
So Monday is a holiday, so, Wednesday, Thursday, and
This week
Friday.
is really slammed. Friday, I don't know, people don't like meeting on Fridays, but
I'd suggest Wednesday.
I would, yes.
She would be able to.
You're not Wednesday, okay.
Well, Friday is due with me. Is that good with you, Mary?
Friday's okay.
Yeah.
Would that be okay with
Mhm.
y'all? Okay, I'm sorry about Friday.
Friday the 21st, is it?
Yes.
What time?
Noon? Is that okay? Noon?
And you're doing a Zoom in this case, right?
Correct.
And,
So a Zoom Wednesday at noon, Friday at noon, on 21st.
and I'll send Mr. McClendon my edited, version after hearing all the discussion. And, Mr. McClendon, you'll send it out to the committee members.
Okay.
I'm still getting back to, the quorum court, and to, make sure that we have some communication in some form or fashion. Now, I don't know if a resolution would be the first entree that we ought to give them or the judge. So, I don't know whether it would be appropriate to get some direction from the judge, or, I don't know, the quorum court has committees. I don't know if there's an appropriate committee, but, I'm real sensitive to putting the cart ahead of the horse with the diplomacy of us ultimately wanting the quorum court to approve what we do. So, if there's any guidance that you can give us as to, the general diplomatic way that ought to be
Well,
done.
let me give that some consideration. I think it would be appropriate to communicate, this body's responsive to the full board, the board, by its design, it's supposed to make recommendations and provide guidance to the full board on matters of land planning policy. And so I think alerting them to the fact that this process has begun, and if they've made this decision, I think that's appropriate, and asking for resources in order to make that work is appropriate. But kind of on the softer side of diplomacy, let me get some thoughts as to how it might work.
Okay, and I guess if you communicate with either Christie or Van, would be the, because like I said, I was at the city council and our planning commission, most of the time we followed what they said, we didn't have to.
Right.
When we get to the point where the planning board begins to consider what the subcommittee has provided and have a public hearing at their, then maybe it would be a good time at that point for the chairman to write an email to the judge and the quorum court to say we're considering this and it's likely to be coming in the near future or something, you know. Y'all can direct the chairman to
Well,
do
you know,
that.
one thing about it, and you know, those folks are here, this is gonna be a really very interesting topic that people will want to become involved with.
They'll become involved, I promise.
And so, you know, like I said, this is, you know, it's gonna take a lot of time and effort on behalf of the planning commission, certainly this committee. And I wanna thank Christie for starting this ball rolling.
Thank you, Mary.
Sure.
With the community especially.
Absolutely, because I think it's critically important, you know, that we try to get something in place. Because right now, there's a lot of folks that don't want what we're talking about doing to happen. And depending on what we do, of course. So, I appreciate your leadership and certainly, you know, man, and again, man, I want to try to put this committee and the planning commission in the best position to, you know, work with the former court and delivering a meal that they can digest.
Well, thank you all for coming. I'm gonna jump to end, and, before we adjourn, I'd like to wish Mayor Hayes, happy 75th. I think that was on the 8th.
And January 8th, me and Elvis Presley.
We have the cards.
Oh, well, thank you,
And
Christie.
we have cake.
Oh.
So we'd like you to have nothing but cake. We'd like everyone here to grab one of those, please. And if there's leftover, I'd like for the judge to have one and Angela,
Oh, okay. Well, Angela's, well,
if she doesn't want to take that.
no, that's okay. Thank
Well,
you.
that was very nice, thank you. And yes, 75 years, thank you all very much, and no more gifts, please.
So I move to adjourn. Thank you all.
Both must stand.